First of all, welcome, and thanks to all of you for braving this nor'eastern to come to this event. My name is Johanna Wald. I'm the Director of Strategic Planning at the Charles Hamilton Houston Institute for Race and Justice here at Harvard Law School. On behalf of Dean Minow of Harvard Law School and the Houston Institute, I really want to welcome all of you and thank you for coming. Today we have an absolutely remarkable panel to discuss voter suppression in the 21st century. 100 years ago, we were dealing with poll taxes and literacy tests. Today we're dealing with voter identification requirements, some quite stringent, reduced voting opportunities, hours, and regulations of voter registration. The tactics are different, but the goals are the same, to keep certain qualified members of our democracy from voting. Since 2003, in this current wave of voter identification, or of voter suppression, since 2003, 22 states have legislated new restrictions on voting. Some of them far more onerous and stringent than others. The pace was accelerated dramatically after 2010, when so many of the state houses flipped from Democrat to Republican, and a lot of governors turned Republican. After the 2014 elections, we expect certainly that there are going to be several additional states that are going to at least make an effort to legislate new requirements for voting. We're extremely fortunate today to have an absolutely remarkable panel, including two of the leading experts, lawyers who have litigated challenges in the states, David Gersch from Arnold Porter and Kathy Culleton-Gonzalez from the Advancement Project. Both of them have led national coalitions of organizations, including the ACLU, the Lawyers Committee, to litigate these cases and challenge these new voter identification requirements in court. They're going to talk about the battles. They're going to talk about the kind of status and where some of these challenges stand. In addition, we've got Richard Sobel, who's a noted scholar who wrote for the Houston Institute the report that most of you have right now called "The High Cost of Supposedly Free Voter Identification Cards." And what Richard did was he went and documented the actual costs incurred by individuals who tried to obtain supposedly free voter identification cards in 3 states, Pennsylvania, Texas, and South Carolina, that had legislated new voter identification requirements. So the way that the format for this is we're going to have all 3 speak and present, because I think that as a result of the sort of 3 panelists, you'll get a kind of more comprehensive picture of the status right now and what's going on in terms of voter identification. And then I will open it up at that point for questions. So hold on to your questions. And I want to welcome the 3 panelists and thank them. 2 of them flew in from Washington, D.C. today. And Richard flew in from Chicago yesterday. So again, thanks so much for braving the storm. And so I'm going to start with Richard Sobel. Richard is the author of The High Cost of Free Voter Identification Cards that you have. It's a Houston Institute report that was released in June. And the study calculates the actual costs involved by different individuals who had to obtain free voter identification cards in Pennsylvania, South Carolina, and Texas. So the study is, he used court documents, and he'll talk about his study, and he used media reports, but these are real individuals. Richard's a research associate at the Houston Institute. He's a non-resident fellow of the Hutchins Center at Harvard and a visiting scholar at Northwestern. He's the director of the Cyber Privacy Project. And he contributed to the amicus brief in the Crawford versus Marion County U.S. Supreme Court voter ID case in 2008. He also edited the Symposium on Voter ID Issues. I also want to say that Richard came to us back in 2006 to the Houston Institute when we were just getting going, and he urged us to really look closely at these voter identification issues. So Richard is very prescient. He at the time, Indiana was one of the few states that had passed this, and he said, you have to look out for this. These are very dangerous. So Richard's been sort of on this for a very long time, and he will now talk about his study and what it means.
Thank you, Johanna. I want to thank Johanna and David Harris and Kelly Garvin and Ernest from the Houston Institute and Charles Ogletree, and also thank the Hutchins Center, where I've been a fellow in the past, and Skip Gates and Abby Wolf for co-editing this. What I want to talk about is the context and some of the information about the cost of a so-called free voter ID and how that fits in with the fundamental right to vote and how it abridges it. Quick historical review. After the Civil War, during Reconstruction, the 13th, 14th, and 15th Amendment were supposed to overturn a legacy of slavery, give black people equal protection, the right to citizenship, and to voting, the 15th Amendment. And during a brief period, there was a flurry of actual voting and participation in electing of officials. If any of you have seen the wonderful Finding Your Roots program that Skip Gates has been putting on for the last few weeks, you'll know that several of the people he was able to trace back to family members right after emancipation. And right after emancipation, at the end of the Civil War, the 13th, 14th, and 15th Amendment, there were two things that people who were now newly free did. One is they got married, and the second is they registered to vote. And John Lewis's relatives and Valerie Jarrett's family traced back to the actual voter registration in 1865 to 1867, which was actually before the 15th Amendment. So very, very significant. But unfortunately, at the end of Reconstruction, during the so-called redemption, we saw the kind of Jim Crow devices that came up that Johanna alluded to: property requirements to vote, poll taxes to vote, literacy requirements to vote. Alex Kazar, another Harvard colleague, has written about this. During the 1890s, not just for black people, but for other immigrants, they would have to show their naturalization papers or their birth certificates. Who is an American? And so voting was really suppressed uniformly, particularly in the South, through the Civil Rights era. And it was only when the Civil Rights Movement began, and then the Civil Rights Act of 1964, the Voting Rights Act of 1965, the Harper decision in 1966, striking down the poll tax, and the 24th Amendment outlawing the poll tax, that we actually see again major black suffrage in the United States. And one of the key points about the Voting Rights Act, and perhaps Kathy or David will talk about this, was the pre-clearance requirement, that laws that affected elections needed to be reviewed by the Justice Department before they were implemented. And voter ID was one of these issues, though voter ID really needs to be put in the context of other ways of suppressing the vote that we'll talk about: reducing early voting, purging polls, felon disenfranchisement, which the Houston Institute has followed very closely, spoiled ballots. Many of the voter ID requirements are justified by voter fraud. And it's important to begin at the beginning to look at this as an allegation and to see that here are the number of voters that we have and actually voting, and the number of alleged cases of fraud in a state 1 to 3 in the states that I studied. I'll show you a little bit later a decision that says you're more likely to be hit by lightning on a day like today than actually see voter fraud. I always, as a political scientist and constitutional scholar, I always want to put the questions of voting into the fundamental rights category, because that's really what's at stake here: the right to vote, the right of citizens to vote, not just the burden, which is a lot of what we'll talk about today, but the right to vote in Article 1, Section 2 of the Federal Constitution as a First Amendment free expression and right of assembly right. Amendments like the 15th Amendment, the 19th Amendment, and the 26th Amendment, protecting that. I think that one of the judges in Wisconsin was very eloquent about this, that he says the problem with voter ID laws fundamentally is they invert the relationship between government by the consent of the governed to a situation where government officials say who can be licensed to participate in voting. And I think that really puts it starkly. As many of you know, the constitutionality on its face was tested in the Crawford decision, and for the Indiana law, 2006, one of the things that I brought to Johanna's attention and David's quite a long time ago, the plaintiff, key plaintiff, William Crawford, said he was offended that he had to show ID to vote to people who had known him for years. And fundamentally, that's what's at stake, the offense against the right and against the personhood of American citizens. So we're looking at a fundamental right. But as one of the other judges in Wisconsin has done, it's really the combination of the offense to the fundamental right to vote and the burden that can be demonstrated to individuals and also to organizations that really strengthens the case against voter ID. Many of you know that the battle against voter ID was in many ways affected detrimentally by the Shelby decision, and perhaps Kathy will talk about this, where preclearance was undermined because the formula was undone. There's still possibilities under the Voting Rights Act, and again, I think Kathy will talk about that. But some of the things that could be prevented up front now have to be attacked after the fact. And in the Texas case, whereas the district court judge struck down the Texas law as unconstitutional because, and Justice Ginsburg echoed this in her dissent when the Supreme Court refused to stay the implementation, the voter ID laws are actually poll taxes, and they represent, in many cases, intentional discrimination. So let's do a quick overview of where voter ID laws are. Johanna mentioned this a little bit. About 22 states have passed voter ID laws, though fortunately some of them have been struck down. About 10 of those states have strict laws, which means that you have to have an official government photo ID, and it has to have an expiration date. It has to not have expired, or it has to have expired within the last few weeks. Absent that document, usually a driver's license, you cannot vote. There are sometimes small exemptions. One of the most interesting ones is that some of the states have exemptions for religious reasons. If you don't believe in photographs or official photographs, then you can get an exemption for that. Another about 10 states have non-strict photo ID laws where you are asked for photo ID, but you can get around it if you don't, having a combination of other government documents. About 19 states have non-photo ID requirements. You have to come up with those government documents. You're not necessarily asked for a photo ID. And about 12 states have no requirement whatsoever. You simply walk in and give your name, maybe your address. So still, the majority of states, you don't need a photo ID in order to vote. But as we may talk later, particularly the switch, Johanna mentioned the 2010 switch, 2014 switch in state legislatures, we may very well see more voter ID laws. But currently the norm is not to have a voter ID. Now, one of the questions that we want to talk about, and this is a tough one for social scientists, is what is actually the impact of these voter ID laws on turnout, and particularly on minority turnout. The statistics are clear. Minority members, particularly blacks and Hispanics, are much less likely to have a driver's license, much less likely to have a car, and therefore there's a disparate impact on their likelihood of being able to vote. But we actually need to demonstrate that people are prevented from voting for not having voter IDs, and that's a little bit tougher. I'll talk a little bit about the GAO report and how they went about that. But I want to just quickly go through and give you a sense of how you figure out what the cost of a free voter ID is. So this is Pennsylvania, And we want to know how much it costs to get a free voter ID. I don't want to go through the details of this, but you can see that at the end, it costs in Pennsylvania about $100 to $175 to get a so-called free voter ID. There are out-of-pocket costs, and then there are time costs. Okay? Now, the question is, and this is about similar for another state. This is Texas, estimating from about 75 to 150. So it's fairly consistent across those states. Now, the question is, what are these costs doing to turnout? And some people pay the costs and can't get the ID. Some people can't afford to pay the costs, and some people just won't even try. And some people won't show up to vote. Once again, Kathy, I think, is going to talk about this. But we want to have a sense of how many people voted and how many people didn't vote because of the voter ID. The General Accountability Office did a report in 2014 to try to estimate the impact of voter ID laws on turnout. And they estimated that in Kansas and Tennessee, which David can describe, I think, as very strict voter ID laws, they estimated the turnout between 2008 and 2012 was reduced by about 2 to 3%. Now, that doesn't seem like a lot, but in a close race, that could be tens and sometimes hundreds of thousands of people who don't vote. And as we all know from the 2000 elections and many others, that can be a deciding factor. If only the GAO estimated 2 to 3% reduction, if you only take 1% of roughly 30 million voters, it's 300,000. If you take 0.1%, as Stephen Salaba here has estimated, it's still 30,000, maybe to 60,000. Across 20 states, that's a significant number of people. So this is one of the questions we really need to answer more, and we can work on that. But we can see that there is some impact there. Now, when I tried to estimate for the Houston Institute report the cost, I wanted to estimate the direct cost and the time, what's called the time tax. How much time do you have to spend in line? How much time do you have to spend traveling? And also the travel costs. Bus fare, if you have to rent a car, cost of renting a car if somebody else goes, the cost of gas, adding those things up. And I used a very low figure. I used the minimum wage for the United States as a time factor. Only about 5% of the population, fortunately, earns the minimum wage. So these figures of $75 to $175 is probably a vast underestimate. And of course, if you have to have legal help, for instance, you have to get your name has changed because there's an error on your birth certificate, or you got married, it can add significantly to the costs, adding hundreds and even thousands of dollars of legal fees. And once again, as perhaps Kathy will talk about, there's some people who simply can never get a voter ID because they can't get the underlying documents. So I want to quickly try to put in context what the question is. The allegation is that there's voter fraud, and we saw in that earlier table, and it's repeated here, that there's 1 to 3 proven cases of voter fraud in these states. So we're dealing with a very small amount. The cost of implementing voter ID programs to the states, not just to the individuals who want those IDs, but to the state governments, can be significant. And the fees can run to millions of dollars per cases of fraud. Now, I can't go through the details, but you can see them in the report from News 21, the analysis of voter fraud. Interestingly, in the Wisconsin case, which was a Seventh Circuit case, Judge Posner, who wrote the original voter ID case Crawford decision and accepted Crawford back in 2008, has come to rethink this question. And he has looked at both voter fraud and at the cost of a voter ID. And Judge Posner talks about down here the likelihood of actual voter fraud is perhaps one case out of 15 million. And the likelihood of being struck by lightning, be careful when you go out, is about 1 in a million. So fraud is about 15 times less likely. I was pleased then that Judge Posner also cited my report in here as actual, the amount $75 to $175 of the cost of getting a voter ID. You don't need a voter ID, arguably, to get and exercise your fundamental right. I just want to add a short footnote. Judge Posner also mentioned in here that you actually don't need an ID in order to fly. So if you can get on an airplane without a voter ID, why do you need one to go into the polling booth? So to conclude, looking at voter IDs is a question of the fundamental right to vote, looking at the burden that is imposed in demonstrating it. The question now is to demonstrate that to the court of public opinion and to the actual courts, that there is a burden to individuals, to groups, and to states, and that it undermines the fundamental rights. And as Justice Ginsburg has recognized and eloquently put in her dissent, voter ID laws are simply the latest antiseptic version of the tests and devices like poll taxes and literacy tests from the bad old days of Jim Crow and modern scrubs. This is sort of my verbiage. So it's deja vu all over again, but having the tools and the knowledge of what's going on means that there's the opportunity to move in a better direction and retain the fundamental right to vote. Thank you.
Okay. Thank you very much, Richard. Our next speaker is David Gersch. David is an experienced commercial trial and appellate lawyer at the Washington, D.C.-based firm Arnold Porter, where he's worked since 1982. He also has always maintained a significant pro bono practice. He's worked with the ACLU, the National Center for Reproductive Rights, the Southern Center for Human Rights, and various other organizations. In 2006, David established Arnold Porter's program for representing indigent defendants in Supreme Court. In 2012, Mr. Gersch resigned from Arnold Porter's partnership and became senior counsel so that, among other things, he would have more time to devote to cases like the Pennsylvania voter ID law case. Mr. David and Arnold Porter brought the case, along with the Advancement Project, the ACLU, and the Public Interest Law Center of Philadelphia. David took the lead in the first trial of that case and argued that appeal in Pennsylvania Supreme Court. Thank you, David, and over to you.
Thank you, Johanna, and thank you for having me. I very much appreciate it. And thank you, Richard, for doing that study. In future cases, I think that'll be very valuable to us. I'm going to talk a little bit today about the Pennsylvania case and some of the practicalities of litigating one of these cases. I want to start, I'm going to go back a little bit before where Richard takes up. One of the issues for us is the other side makes what, for most people, sounds like a common sense argument. They say, well, you ought to have to show ID to vote. And while it's not literally true that you need driver's license or its equivalent ID for everyday commercial transactions, that's what most people use in those transactions. They're used to using it, and they say, well, if I've got to show this to cash a check, if I've got to show this at the airport, is voting really less important than those things? And surely it's not. And it's not, you'll find this view among people on what I'll call the other side, and you'll find that view among people on our side. My son played soccer during this period on a team that was principally immigrant and first-generation kids, and I said to our Algerian manager, what do you think about this? And he said, David, I had to have papers to come into this country. Of course you have to have papers, you have to show them. So this was a tough argument for us in the litigation. Having said that, when you test that against the facts, we win that argument. And the reason we win that argument in court is that notwithstanding its appeal, what becomes clear is that not everyone can get that form of ID. And the heart of my position has always been in these cases, look, you want people to have ID, you're going to have to give it to them. And these people, there's a chunk of people who don't have ID today. And I'll talk a little bit more about that. Let me talk a little bit about the Crawford decision that was mentioned. Crawford was a 6-3 decision out of the U.S. Supreme Court. It was in 2008. It upheld the Indiana voter ID law. The other side would take the position that what Crawford stands for is the proposition that voter ID is constitutional. That's not actually what the court said. What the court said was you've got to balance the burden on the voter against the legitimate state interests. And in the Crawford case, what the court said was, plaintiffs, you didn't come up with a concrete case of what the burdens were. And one of the very valuable things that Richard is doing in his study is making concrete what those burdens are. When we were approached in Pennsylvania, the first thing that we all thought was, we've got to make a great record as to what the burdens are on people for getting ID. What's the effect of these laws? And we did that in part because we wanted to be able to satisfy a Crawford type of test. Having said that, it was our strategic decision that Crawford was not a helpful case for us and that we wished to avoid it. And so we sued in Pennsylvania, not under the federal constitution, but under Pennsylvania's state constitution, and we sued in state court. That was the first big decision we made. So let me talk a little bit about Pennsylvania. I should go back and say one other thing, which is we did not have the data that would have supported a Section 2 case under the Civil Rights Act, so we didn't go that route either. We do now, but we did not have it at the beginning of the case. So Pennsylvania, the timeline of this case was, for me, coming out of commercial practice, was extraordinarily compressed. I was going on vacation. The law was passed in March of 2012, not long before the election. I was going on vacation the day I was approached. I got into the case the first week in April. We sued on May 10th of 2012. And in between that first week in April and May 10th, we came up with a legal theory. We found the plaintiffs. We retained the experts. It was an enormous push by the groups that were involved in this to bring it off. And then 2 months later, mid-July, we tried the case for 2 weeks in Superior Court in Pennsylvania. We put on what we thought was a great case. I'll talk about that a little bit more. We lost the case in August, okay? We took an emergency appeal to the Pennsylvania Supreme Court. I argued that in September. We're now less than 60 days before the election. The court ruled at the end of September that the trial court was wrong. They threw out the decision, and the court sent us back to trial at the beginning of October. We're now 1 month before the election. And at that point, we finally obtained a preliminary injunction to enjoin the law from going into effect. We went back the summer of 2013. We tried the permanent injunction case. We won that at the end of 2013. And at the beginning of this year, Governor Corbett of Pennsylvania, no longer governor, he decided he was not going to contest the case, and he dropped the appeal. So the law of the land in Pennsylvania is there's no voter ID. Let me go back now and talk about some of the things that I think made this case what it was. So the first and most important thing is we needed plaintiffs. We needed people to say, I don't have ID, I've tried to get it, and I can't. And in the end, we got 60 people who said either I can't get it or it's very, very hard for me to get it. And that really was the backbone of the case. The key person, and we had several people like her, Vivian Applewhite, who was the named plaintiff in that case, was a woman who had marched with Dr. King. She had been a poll worker for a lot of her life. She was a terrific plaintiff. She had voted in every election since FDR. And they were going to prevent her from voting. She had been in the subway in Philadelphia. A thief had cut the strap on her bag and run off with her purse and her ID. Vivian Applewhite was born in the South. She was born outside of a hospital. She didn't have a raised seal birth certificate, in addition to which She grew up with a foster family. I don't think they were technically her foster family, but it was a different family than her birth family. She took their name. She didn't have a birth certificate, and she also had no tie between the non-existent birth certificate and what her name was. And she went repeatedly to get ID from the Motor Vehicles Bureau, which there is called PennDOT. So when I refer to PennDOT, that's the Motor Vehicles Bureau. She went repeatedly, and she was repeatedly turned down because she didn't have the papers. And we had several people like that. Not all of them were as sterling as Vivian Applewhite. My personal favorite was a guy named Danny Garrett. Danny had substance abuse problems. He had served in the Air Force in the 70s. He fell on a period of bad times. He lost his papers. But the reason Danny was my favorite is it became clear to me, listening to him, I could tell by his accent, and he confirmed it for me, Danny had grown up in my neighborhood, and he was just 2 years older than me. Danny was a kid from my neighborhood. He had been honorably discharged from the service, and they were going to take away his right to vote because he didn't have ID. He'd gone repeatedly also. One thing that made this case, and one thing that why we were able to come up with such great plaintiffs, is really a tribute to the lawyers in Philadelphia. So there are a number of legal clinics for the homeless, for the poor, in and around Philadelphia. And those lawyers who were working with these people on a whole series of problems had nothing to do with voting. One of the problems that their clients were running into is they had no ID. So contrary to this popular perception that, oh, ID must be easy to get, so if you don't have it, you must not care. Out of the 60-odd people, we had all but one of those people basically wanted the ID. They wanted ID. We had one person who basically thought it was a police state notion, which is close to my heart too. But you know, your clients are your clients, and they needed ID. They needed ID. This was not for them just about voting. They wanted ID because it made their lives easier. And these lawyers, and we put the lawyers on the stand too to talk about the difficulties, you know, would explain that, you know, places like New York State, you know, if you needed a new, if you needed to get the papers that would make the connection between, say, your foster name and your birth name, you'd have to file a lawsuit. It wouldn't be a contested lawsuit, but you actually have to file an action in court in order to have that happen. So it's very difficult. There's a group of people for whom it's very difficult to get ID. And that was a key part of our case. We also had survey experts, a survey expert who did a phone survey in Pennsylvania and established the number of people who didn't have ID and the fact that the people who didn't have driver's license forms of ID were also unlikely to have any alternative form of ID that would have been compliant under the law. And lastly, and here, for those of you affiliated with Harvard, is a great shout out to Harvard. Lastly, we established that the state knew that there were people who couldn't get ID because they couldn't get birth certificates. And the reason I mentioned Harvard is we had a young lawyer, Rosemary Zaney Nay Smith, class of 2009 out of Harvard Law School. She was trying her first case, and she got the state's head of public policy for the Commonwealth's Department of State to admit that of course they knew that there were people who couldn't get birth certificates. And of course they knew that there are people who didn't have their social security cards and that those people were very likely not going to get ID. So we had a great case on the merits of whether everyone could get this driver's license ID, which the state thought was the key, or the universal kind of ID that everyone would be able to get in order to vote. That's what they kept assuring people. Everyone will be able to get ID, and that's what they had in mind. So we put on a great case, and what happened? We lost. And how did we lose? We lost because right before trial, the state said, you know what? To make things even better than they already are, we'll introduce a new form of ID, which will be easier to get. It's not in existence now, mind you, but sometime after the trial and before the election, we'll make it available. I kid you not. And the trial judge found that persuasive. We went up to the Pennsylvania Supreme Court. We made all of the big picture arguments as to why this was a bad thing. But what the case really came down to is, and what we got a unanimous court to throw out the decision. There were six judges on the Pennsylvania Supreme Court. 2 wanted to reverse outright and rule for us. 4 threw out the we're at least willing to throw out the decision below. And what the court choked on was they couldn't stand the notion that here we were 60 days before the election, and I think we'd established that there were going to be over 100,000 people and maybe many hundreds of thousand people who didn't have ID. And these people, it would just be a disaster and really a terrible showing for the state. Yeah, this is good because it's the dramatic part of my talent.
Right.
Now I'm a seasonal resident.
Right.
First step. Yeah, exactly. Exactly. We'll talk about that afterwards. All right. So we went to, we took our case to the Pennsylvania Supreme Court. Little side note, there's 7 judges on the Pennsylvania Supreme Court at the time, 4 Republican, 3 Democrats. However, one of the Republican judges was the subject of a grand jury investigation, and she was later indicted and convicted. So her colleagues asked her to stop sitting on the cases, not just our case, but all cases, and she refused, whereupon they all voted that the consideration of the court would be done without her. So she was excommunicated. So it was a 3-3 split, but as I said, we got every vote on the court to throw out the original judge's opinion. So there we are. It is now a month before trial. We went back for a trial on remand. And at that point, the issue before the court was actually quite limited. The Supreme Court said, look, there's supposed to be liberal access to IDs. The state has said that it has this new, easier to get ID. Unfortunately, the trial was held without the benefit of being able to test whether it is easier to get. Go back. I don't want to rely, Judge. The Supreme Court said we don't want to rely on the predictive judgment of the trial court. Go back and figure out if there really is liberal access. And of course, there was not, for a couple reasons. One is they hadn't told anyone about it. They bragged that they had a multi-million-dollar ad campaign, but the campaign never explained how you could get this easier form of ID. It was really quite something. And the other, of course, was it wasn't that easy to get. In many cases, you'd have to go back to the to PennDOT on multiple occasions to try and get the card. So we got the preliminary injunction, and you know the rest. The president won re-election. I should touch on 2 quick other facts that were important to winning. One was that in the middle of the case, the Speaker of the legislature, Republican, Bob Michael, said he told a Republican caucus, unfortunately for him, on video, with great, he wants to take credit for this. He said, the voter ID has been passed, and this will deliver the state for Governor Romney. Which was wrong and bad for him in so many ways. The other thing was that the state admitted during the trial that they had no evidence of any case of in-person voter fraud, and that they would not take the position that but for the failure of the law to go into effect, there would be voter fraud in the 2012 election, both of which were terrible points for them. All right, that brings us to the last phase, which is the trial we had in summer of 2013. That was the trial on the permanent injunction. And that was a little tougher because now we were no longer about the driver's license ID. We were about this new, supposedly easier to get ID. And we ultimately carried the day. And there were 3 basic arguments that did it for us. First was we said, look, this easier to get ID, this is not guaranteed by statute. This is solely at the discretion of the state. And that's because that's what the state said, right? Their witnesses said, we're not required to have this ID, but we will create it to make things better for people in the state, and we can get rid of it anytime we want. So our position was real simple. You know, if you're going to require ID, you at least will have to make it available, and it can't depend on the whim of the state whether or not there's a form of ID that you can get. The second point we made was that the entire concept that you were going to give this supposedly easier to get ID through through PennDOT, through the Motor Vehicles Bureau, made no sense at all. That is, if what your goal is to make sure that people have the ID they need to vote, you would never distribute it through this way, because there are approximately 9,000 polling places, but only 70-odd motor vehicles locations. And of those 70, first of all, there are 9 counties in Pennsylvania that don't have a PennDOT location in there. There are another 10 to 20 where they're only open 1 or 2 days a week. It just makes no sense whatsoever. It was very clear. They never wanted people to get this in the first place. And that leads to the last point, which is the idea was not as easy to get as they claimed. It was implemented terribly. They never, even after we had won the preliminary injunction part in this ground, they never told people about the ID that was supposedly so easy to get. They said that was, they thought it would be confusing to give people too many options. You know, in the end, we prevailed. A couple quick lessons, and then I will turn it over to Kathy, especially since you guys have been kind enough to stay so long. The factual showing is everything, right? The key to the case was getting these 60 people who would say, I've tried to get a birth certificate over and over again and I can't. Or, it's very hard for me to get to the Department of Motor Vehicles. I have no car. My family doesn't have a car. I'm infirm. I went once. They made me wait for 3 hours. I can't do it again. We had person after person give that kind of testimony. It was extremely powerful. We backed it up with, in the second trial, we had statisticians, we had survey experts, I should say the third trial. You got to make that factual showing. And again, the work that Richard has done in terms of what this costs money. This costs money. All those things go into the mix. The other thing is the easiest cases, I shouldn't say the easiest, they are all tough, but the more advantageous cases to bring are the cases in which the form of ID that's being required is the strictest, because those are the easiest ones to attack. The case actually got harder when they said they made the ID easier to get. In fact, it turned out there were the problems that I've discussed, but that's a harder kind of case to bring. All right, thank you very much.
Okay, before introducing Catherine, I just want to thank all of you for not only showing up in this incredible storm, but coming back after after that fire drill. So a big round of applause for all of you for coming back.
Johanna, can we go to like quarter of?
Yes, and until someone kicks us out, we'll stay here.
Okay, well,
Yeah.
Kathy's got a cab, but
That's
a
true,
little bit longer.
So Catherine Colleton Gonzalez is a senior attorney and director of voter protection for the Advancement Project, where she leads a team in litigation policy, coalition building, voter education, and community empowerment strategies to protect fundamental voting rights. Before joining the Advancement Project, she served as senior attorney in the voting section of the Civil Rights Division of the Department of Justice, where she brought a series of cases to enforce anti-discrimination provisions of the Voting Rights Act on behalf of Latinos, African Americans, and other voters of color across the nation. Her cases and enforcement actions have helped tens of thousands of Puerto Rican voters in New York, New Jersey, Ohio, and Florida. Currently, she is serving as the Advancement Project's lead attorney in LULAC versus Daninger, challenging Wisconsin's discriminatory voter ID law under Section 2 of the Voting Rights Act. So Kathy, please talk to us.
Thank you so much. It's really, I'm very, very delighted to be here. Thank you for staying and coming back after the alarm. I'm just, humbled to be on this panel. I can't thank Richard enough for his study, and also the Institute for their support of our organization, Advancement Project. And also, I would be remiss if I didn't also say thank you so much to Arnold and Porter for litigating the Pennsylvania voter ID litigation. And they're also our pro bono firm in the Wisconsin case that I'm going to talk about. They just have done so much for voting rights in this country. And I'm also an Arnold and Porter alum, so I feel very honored to be able to sort of come back and collaborate in this way. So I have some slides because I have a lot of information and I want you all to see, the sources of my information. And I'm gonna just come over here, I guess, so I can see. I was asked to cover 2 topics for this conversation. One is the post-Shelby landscape or panorama on voter ID. And I have to say we're in the midst of a war in voting, so it's not just voter ID laws, and also the November 2014 election. And these two things, I'm also with a nonpartisan organization. I want to make that very clear. And I think that, in our country, both parties have engaged in discriminatory voter suppression. But the big question that everyone's debating is there an impact on turnout, and what's going to happen between now and 2016? And are these forms of voting restrictions, not the new Jim Crow, especially in the face of changing demographics? We know that by 2060, probably the voters in our country will no longer be majority white. And so we're seeing a backlash in so many ways on so many civil rights issues, including voting rights. Right now. So this is a slide about the post-Shelby panorama. On June 25th of 2013, the Supreme Court decided that Section 5 of the Voting Rights Act was no longer constitutional. I'm not really sure why. I attended the hearing. We did an amicus brief, and there's really not a lot of logic behind it. So let me just explain what happened, okay? So what happened is that these states and these counties, most of them the South and the Southwest, had been covered under Section 5 of the Voting Rights Act because they had a history of discrimination in voting. And Section 5 of the Voting Rights Act required that any change in voting, and I want to emphasize the word any, literally any change in voting, needed to be pre-cleared by a federal court or the Department of Justice to determine if it would be retrogressive, which is another way of saying discriminatory impact. Of course, if there was discriminatory intent, that was also a violation of the Voting Rights Act. But the pre-clearance provision actually was applied in South Carolina to its voter ID law. In the middle of that litigation, South Carolina promised that it would make broad exceptions, and you could simply sign an affidavit in order to be able to vote, and so that's how that was pre-cleared. Georgia was pre-cleared under some controversy, and Texas in 2012 was stopped under Section 5 of the Voting Rights Act. An advancement project, by that time I joined an advancement project, and we were part of that litigation, and stopped Texas's voter ID law, the strictest in the country. So we've stopped a lot of discriminatory voting changes in Florida. I spend a lot of time in Florida. I want to go on vacation one day, but as a voting rights lawyer, no, we're just there working on Florida. We stopped a discriminatory purge in 2012. We stopped many bad voting restrictions in Florida under Section 5 of the Voting Rights Act. So even though only 5 counties were covered, if there were implications in those 5 counties of a state voting change, we were able to stop it. And if you look and see, on this map, I chose it because there's so many little counties in all of these states. We're talking about the tip of the iceberg. It's easy to find out about a new voter ID law. It's really, really hard what we're doing. Richard's study is just going to be so helpful. The litigation is very, very difficult, but those are the easiest things to find out about. So what happened is on June 25th, 2013, based on a theory that goes back to the reconstruction of states' rights and the equality between states, the Supreme Court held that the past history of discrimination shouldn't make these particular jurisdictions have to go through extra federal oversight. So now we have no pre-clearance, and to make a long story short, little hope of getting it back before 2016. So let's see. There have been 3 cases in 2014 about voter ID laws, and they're in this sort of overall panorama of a war on voting. And I was listening to David, just thinking about how busy we were this year. One of the things that that's interesting about voting rights law is that the jurisdictions make a lot of changes really close to an election, and there's sort of an automatic accelerated deadline because what's at stake, our democracy, right? So in Texas, the voter ID law was stopped by Section 5. 2 hours after the Shelby decision, the Texas Secretary of State tweeted that they would reinstate it. And in the Section 5 litigation, we hadn't proven discriminatory intent because we didn't need to. Intent is kind of hard to prove, but we didn't need to. We just wanted to stop it. So we proved discriminatory impact. Advancement Project wasn't part of this next case, VZ v. Perry, that was brought under Section 2 of the Voting Rights Act. And let me just say, Section 2 is kind of what's left after Section 5. There are other provisions too, but it's a nationwide prohibition on discrimination in voting. And it also says any voting procedure that results in less opportunity to elect candidates of choice by voters of color is prohibited. So it's any voting procedure. So that would include voter ID. Some people think that shouldn't apply to voter ID. I really don't see why. At any rate, we've been applying it to voter ID, and colleagues in the voting rights movement brought Section 2 litigation. In October 9th, 2014, there was a permanent injunction on the merits by Judge Gonzalez in the Southern District of Texas, finding that Texas's voter ID law violated Section 2 on the results test or the impact test, but also that it was intentionally discriminatory, that it violated the Constitution under the Crawford test that we've been talking about, and that it was an unconstitutional poll tax. Judge Gonzalez also found that an estimated 600,000 registered voters did not have the kind of strict voter ID that would be needed to vote if this were to go through in November of 2014. And I think that she said it was a grave understatement that there was disparate impact on African Americans and Latinos, and much less likely to be able to have this type of strict ID than their white counterparts. And so the evidence was pretty clear. So Texas immediately filed for an emergency stay, and they went up to the Fifth Circuit and they granted Texas's a motion for a stay pending appeal. And that was on October 14th. The plaintiffs, LDF and the Lawyers Committee and the Brennan Center and on behalf of LULAC and the NAACP, as well as the Department of Justice who had intervened, filed an emergency application to vacate the stay with the Supreme Court on October 15th. We were shocked that the Supreme Court issued an order denying the stay. The opinion is actually just a page. It's really short, and it talks about changes being made too close to the election. But this voter ID law had never been implemented in a major election. So this discriminatory, unconstitutional voter ID law was the real change. So I disagree with that. And the case is to be continued. But in the meantime, for the first time since Texas became covered, since 1982, is when Texas became covered under the Voting Rights Act, an intentionally discriminatory voting procedure was allowed to be implemented in an election, first time. North Carolina was the first state to actually pass a new law restricting access to voting after the Supreme Court's decision in Shelby, and it passed the most comprehensive voter suppression legislation in the country, HB 587. You can see what it did. All of these 5 components have a disparate impact on African Americans and Latinos, and I've put in red that they also enacted a strict voter ID law, which prohibits even college IDs and any out-of-state IDs from being used for voting. That hasn't been implemented yet, but we've brought a complaint about it, and moving right along, we're going to have a trial on the merits in the summer of 2015, but before we could even get there, we tried to get a preliminary injunction, and on the 2 things that, on some of the things that were in place. So the voter ID law is something that's going to be in place for, that's proposed to be in place for 2016. And those were cuts to same-day registration, which is proven to increase participation, and out-of-precinct voting. And so out-of-precinct voting means that if you've recently moved, but you still want to vote, you haven't had a chance to update your registration, you can just go vote in your new precinct, and they won't count the local elections, but they will certainly count the top of the ballot. And so those cuts actually directly affect particularly African Americans, but also Latinos. And so the Supreme Court denied a petition that we filed, that's our co-founder Panda Hare behind there, and we represent the North Carolina NAACP, and we had overturned a bad lower court ruling, and the Fourth Circuit got a good ruling, and then the state went to the Supreme Court, and so those were allowed to be implemented in November of 2014. So there's 3 cases. Oh, I'm sorry. This case is to be continued. It's really hard to read, but I want to tell you, this is a photograph of the Moral Monday movement, the Forward Together movement. We're building we in the voting rights movement, I should say, are building a next generation voting rights movement because we really need to. We need to build a next generation civil rights movement in this country. So we just have the honor of working with great, great community partners as community lawyers, including Reverend Barber, who has built the Forward Together movement. So all of the folks that you see actually got arrested week after week after week and marched so many times and are continuing to march for basic fundamental civil rights in the state of North Carolina. And I think it's an idea that we also see coming around other civil rights issues to fruition in our country as we see all these protests against police abuse and police profiling. We're going for a trial on the merits in the summer of 2015, and our lead plaintiff is, this is not the same version, well, anyway, our lead plaintiff is Rosanelle Eden. She's 92 years old. She marched with Dr. King. She had to take a literacy test and pay a poll tax to vote. She's, for 70 years, been registering voters. She's had crosses burned on her lawn, and her birth certificate does not have her married name on it, and it would cause her considerable time and expense to get that changed to be able to vote in North Carolina. So, to be continued. The next case is in Wisconsin, and we also, with Arnold Porter and with the ACLU, filed a claim under Section 2 of the Voting Rights Act. So Wisconsin was never covered under preclearance, but Wisconsin is a very interesting state. They had, again, a very, very strict voter ID law, the kind that Richard described, that you need a photo and you need to have an expiration date and it has to be unexpired. And so our lead plaintiff was Deborah Crawford, and she testified that she and her daughter devoted substantial time and expense over many months trying to get her birth certificate in Tennessee. As an African American born in the South, she was not born in a hospital. And that's what makes it so difficult for many folks in this generation to be able to get their birth certificates. But the same is true of younger African Americans and Latinos. And I would say for folks who are naturalized, if you need to get your naturalization certificate, the current cost is $345. So for people who are in immigrant communities, it can be very expensive to get these underlying documents. And so there's a time tax and a transportation tax, and as well as the cost of the underlying documents. And so Ms. Crawford marched with Dr. King as well. Great, great, great leader. She actually passed away before we could go to trial, and her daughter testified on her behalf. And if you'd like to see our website, we have a beautiful video of her talking about what I hope is her legacy. Who's a great leader in the voting rights movement. So the case became LULAC v. Denninger, and we brought this case on behalf of African Americans and Latinos, and that's my friend Darryl Green, who's the vice president of LULAC in the Midwest, and that is, I'll just tell you the procedural history. He's actually really picked up the baton and done quite a lot of organizing, and we helped get so many witnesses and so much evidence that are necessary in these cases. And so we had an excellent lower court decision on April 29th of 2014. Judge Edelman, you can read his decision, talked about the disparate impact of these laws, talked about 300,000 voters, registered voters in Wisconsin not having the type of strict ID needed, and the difficulty in getting them, and proving the discriminatory results that came from what's called the totality of circumstances, or the interaction of these laws with structural discrimination in our country. So in Wisconsin, we also had a number of experts talk about the reason that there's a discriminatory impact on African Americans and Latinos is because of socioeconomic disparities, educational disparities, and a history of discrimination in voting also, and housing disparities, and campaigns that include what we call racial appeals. So, a lot of ongoing racism in our country, and a lot of structural disparities that, make these kind of voter ID laws almost surgically precise in who it is they're going to affect, a disparate impact on African Americans and Latinos. So we drew with great respect for the Seventh Circuit, you draw a lottery, and we got 3 very conservative judges the morning of the trial, and John Hewlin of Arnold Porter did a great job arguing for us, and those 3 conservative judges had their mind made up and overturned the lower court's decision, Judge Edelman's decision. In the meantime, we petitioned for an emergency stay, and on October 9th, the Supreme Court granted our petition for emergency stay, and so there was no voter ID in this election in Wisconsin. But it's to be continued. We're going to still have to go through this on the merits. Think about that we have a difficult lower court decision on the merits. In the Seventh Circuit, we requested reconsideration. Justice Posner, who had supported the Crawford law, also just spontaneously asked his colleagues to request reconsideration, and he issued, and it was a tie, 5-5. And we couldn't get reconsideration of the Seventh Circuit's opinion, and neither could Justice Posner, but he wrote this very, very helpful dissent that cites Richard's study and talks about what we've learned since the 2004 decision in Crawford versus Marion County about the burdens inherent. Also just hammered on the fact that 300,000 registered voters don't have the strict form of ID, and that's 9% of the electorate. So to the 3 conservative justices, that wasn't very much. But to those 300,000 people, that's quite a lot. And there's some other quotes that you can read, and we'll be happy to share this information later, but he also said some of the evidence of voter impersonation fraud is downright goofy, if not paranoid, such as the non-existent buses that, according to the True the Vote movement, which seems to be behind some of this, transports foreigners and reservation Indians to the polling places. This never happened, something made out of thin air that got people very riled up. So, let me just keep going, because I know you've all been here for a while. Part 2, I was asked to talk about turnout data. And so I want to say there's a few caveats to this data. You know, voting rights lawyers, whether we're doing advocacy or we're in court or we're working on communications, we use data quite a bit. And we rely on brilliant social scientists. But for this turnout data right now, I just want to emphasize that we really can't draw a legal conclusion from it. So a lot of things impact turnout. That would be who are the candidates who are running, what is the get out the vote record, and sometimes voter suppression can also impact turnout. But we can't really draw a legal conclusion, or at least I can't. I'm not a social scientist. I'm just going to tell you the data that we have since November 2014. The other thing I want to emphasize is that sometimes voter suppression backfires. So we saw in 2012, I was in Miami, I was in Florida, the lines were horrendous. I met somebody who waited 18 hours to vote. She was African American. I met Latinos, same thing. They had to come back 3 different times to vote. You all saw the President's State of the Union speech, or I hope you still remember Ms. Desleen Victor, a 102-year-old woman who had to stand online on her feet for over 6 hours to vote. But she did that. She really wanted to vote. So sometimes, even when voter suppression happens, people get angry and they decide to vote anyway. So the fact that turnout didn't decrease, or the fact that turnout doesn't necessarily have a direct relationship with voter suppression, isn't the main fact. The fact is that it's not fair for some people to have to try harder to vote than other people in our country. That's the main fact in civil rights law, at least. So just that's a very important caveat, as I'll show you with this turnout data. The other thing is that, as the experts know, you need to look across a number of elections, and you try to find elections and circumstances that are similar to make any comparisons. So with that, I'm going to be brave and show you the data anyway. So I looked at the same US election project data that Richard did, and I was so happy that we looked at the same data. And I found that in states with new voter suppression laws, the average turnout was 38.86%. And in states without new voter suppression laws, the turnout was 40.08%. And let me just run through this, it'll be faster. These are the states with new voter suppression laws on the left, and the other states are on the right. So Wisconsin had another form of restriction since, and the restrictions are those restrictions since 2010, right? So new restrictions since 2010. And so there's the overall turnout in the November 2014 election. We can see the average of the states with restrictions is lower than by less than 2 percentage points than those without new restrictions. Some of the ones in the right column, the restrictions weren't necessarily new. So let me just move on. But that's the definition of let's see what happens. Here are the new voter suppression laws since 2010. I looked at the Brennan Center's list, and we also independently corroborated it. They have great research. Those that are underlined, indicate that they would have been subject to preclearance. So just if you take an eyeball, like those are all the states that would have been subject to preclearance with all their new voter restrictions that there is no preclearance of anymore. And sometimes the Department of Justice or Section 5 in court was able to stop these laws. And the ones that are in red are voter ID laws. Okay. So in states with new photo ID laws, the strict ones, then only the ones that are new, this very preliminary data indicates that turnout may have dropped approximately 5.6%. So these are the states that have new photo ID laws since 2010, and you can take a look at, use the same data source, and this is what's reported in by secretaries of state to the election project. And so we can see that there's been a decrease in turnout of 9.5% in Alabama, of 7.3% in Mississippi, of 3.6% in Texas, and 2.0% in Virginia, but where we were able to get the stay by the Supreme Court in Wisconsin, turnout increased. How does this compare to states without photo ID laws? So nationally, the same US election project data shows that turnout dropped during this period of time from 40.9% to 36.3%. So that's a drop of 4.6%. In the states with the photo ID laws, the drop was 5.6%. So I just want to emphasize again, this is preliminary data. It depends on the state's reporting. Very soon, the census is going to issue data about turnout by race at the state level. They do an American community survey, polling of voters around the country. It's considered to be, the best post-election polling that's out there. And so every major election, every 2 years, the census does this, and they've been issuing it earlier and earlier. And we'll be able to see turnout by race in each of these states, and by gender, and by age, and different factors. So we'll have more information hopefully soon, and we'll be able to see, what the impact was on a more localized level and with a bigger data set. And just the GAO report has also shown that photo ID laws had a negative impact on turnout in Kansas and Kentucky between the 2008 and 2012 elections. And I would also say, if you take a look at the federal court findings on the number of voters without photo ID, even though people say that they don't impact turnout, first of all, that's not really the test, but also if we take a look at the 600,000 registered voters that didn't have the strict form of photo ID in Texas, that's a finding by a federal court. So Judge Gonzalez looked at evidence. It was contested, to say the least, and the experts showed, and the court agreed, that 600,000 registered voters in Texas didn't have that form of ID. So even if only 1% of them wanted to vote, that would be 6,000 voters. It's pretty significant. In Wisconsin, 300,000. So we've also heard a lot about voter apathy, and so hang in there with me. But we look at why America didn't vote, and people think that people don't really care. As it turns out, 20% just don't care. That's all, 20%. This is a small sampling, but 20% don't care. 34% are too busy, or out of town, or sick, or forgot. I would posit that if we made voting more easy, that like in other countries, such as on a Sunday, or something that you can do without having to go through these registration and voter ID requirements and go through so many hoops, that number might go down. But that's just a hypothetical. But over here, we see conflicts with work or with school, or missing the registration deadline, or recently moved, or no transportation. And we see these states putting more and more barriers to the right to vote that fall over on the left side there, and structural reasons. We also know that there are other things that impact turnout, or there are other types of voting restrictions or increasing access than voter ID. And so we see Colorado passed a very comprehensive law increasing access between 2010 and 2014. And turnout went up, even though it was generally kind of low in Colorado because Latinos were kind of angry in this election and didn't want to vote, understandably. And in North Carolina, we can see that turnout actually went up a little bit, but we have the Forward Together movement. We had very, very intense backlash to the voting rights restrictions and the idea that we shouldn't let anything stop us from voting. In Ohio, which cut early voting, And the ACLU litigated a case really brilliantly, but the Supreme Court let the cut of early voting go through for this election. Turnout went down pretty dramatically. And in Florida, where early voting was partially restored between 2010 and 2014, turnout went up just a nudge. So some other things can impact turnout. Let's just talk about the voting trends by race. A lot of numbers are on this slide. Generally speaking, we know that turnout was very, very low in November of 2014. The non-Hispanic white share of the vote only decreased minimally in this past election. And the share of voters of color was as follows. So the African-American level of turnout stayed about the same. Latino turnout looks like it went up, and Asian Pacific Islander turnout looks like it went up. However, it did not. Those two populations boomed in the last 4 years. So Latinos represent over 11% of the electorate and voted at 8% of the electorate. Asian and Pacific Islanders over 4% and voted below, whereas non-Hispanic whites voted at about the same. Again, this is national, very raw data. The census will tell us a lot more. But we need to look at what's happening with changing demographics and which populations are booming. So Latino and Asian American turnout, this is the percent of the electorate. The turnout is actually about 48% in both of those groups, and that is the same level of turnout nationally that African Americans had in 1964 before the passage of the Voting Rights Act. So very, very low among those voters of color. So we also were discussing low Latino turnout, and I'm curious if it's related to structural barriers. I'm from a family that was very mad about immigration and thought, why bother even voting? But of course I voted because I'm a voting rights lawyer. I have to tell everyone to vote. But you may have heard that the Latino community did not have a high turnout, and many people felt very, very frustrated about immigration. But also we know that of a national poll of 4,400 Latinos who didn't vote, found that 14% didn't have photo ID. 25% didn't have time in their day to vote, and 24% didn't know where their polling place was. So this is the only known poll of non-voters by race, by the way, at this time. So it's something I think that we need a lot more research on, the people who don't vote, right? And why it is they didn't vote. So we don't know if they didn't vote because they don't have photo ID, by the way, we just know they didn't have photo ID, right? So Latino turnout's low, I think sometimes because of structural barriers. I know in Puerto Rico, turnout is 85%, and once Puerto Ricans come stateside, it goes very, very low. And by getting bilingual ballots, I've seen turnout go up in the 20 counties I've worked in there. So that's one of the structural barriers for Latinos is language access sometimes. So I'm getting to the end. We need to fix all that. And there are also positive measures. We believe that election officials should not be spending our tax dollars and their time finding ways to make it harder to vote, especially because there really is no in-person voter fraud. And these are the ways that we can fix this low turnout among voters of color. There's 7 different ways, and I keep in there fighting voter suppression, because even though we know we can't always prove that it's related to turnout, we certainly need to fight back. If we weren't fighting back, I don't know where we'd be today. So we're building a next generation voting rights movement. And thank you for being part of it, and please stay in touch.